Good evening. My name is Darren Green. I'm the Vice Chairman of the Union County Zoning Board of Adjustment. This is our January 19th, 2022 meeting of the, can you believe it's 2022? Meeting of the Union County Board of Adjustment. We are now in session. Also on the board tonight, we have Larry Britt, Bill McGirt, Mark Tilley, and our alternates, Dion Edwards and Francis Ward. Also present, Jim King, Senior Planner and Zoning Administrator for Union County, Amy Griffin, who is our clerk to the board, and Derek Thurman, who is the attorney for the Zoning Board of Adjustment. The Zoning Board hears three different types of hearings. First being an application for variance from the regulations in the zoning ordinance. The second being an appeal from a decision or interpretation of the zoning administrator, or third, an application for special use permit. The order of each case will be as follows. All parties who plan to give testimony, either pro or con, must complete the green form, which should be up here at the microphone, in order to be sworn in. Please fill those out. And you will be sworn in order to give testimony to the board. Secondly, a planning staff member will explain why the permit was denied or why a variance has been requested or the nature of the special use permit application. The board may question the planning staff member. The applicant may also question the planning staff member, and then the applicant will present their testimony for the case. The board may also question the applicant. The planning staff member and persons in opposition may question the applicant. The applicant may present sworn witnesses. They will be subject to cross-examination. Other parties wishing to speak, pro or con, will be given reasonable time to present their testimony. They will also be subject to cross-examination. The planning staff member and then the applicant will be given an opportunity to rebut any testimony. After hearing the case, the board will review the case and render a decision. This is usually done following the close of the public hearing and the board's deliberation. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the staff of the Union County Planning Department to receive a decision of the board. All exhibits must remain with the board. Please hand them to the clerk for tagging. If you feel there's a conflict of interest of any member of this board or any association that would prejudice your case, please let it be known at the start of your case. We are a quasi-judicial board and can only accept sworn testimony. No hearsay evidence will be admissible. An appeal from this board is to the Union County Superior Court. You have 30 days from the date of the board's written decision in which to appeal the decision in accordance with North Carolina General Statute 160A-388E. I would remind you to please at this time turn off any cell phones, and I also would tell you that a quorum of our board is 3 or more members, and we have 4 regular members and 2 alternates, so we do have a quorum tonight. Ask, as far as our minutes, ask if there's any changes to the minutes, and that's all I think I have in this time. We will move on to item A, determination of quorum. And again, as I said, we do have a full board tonight, 4 members and 2 alternates. We will determine which alternate will sit on the case here in a moment. Item B is approval of the August 17th, 2021 and October 19, 2021 minutes. Do I have a motion on the August 17th? We'll do them both as a block.
I'll make a motion. We'll do each minutes separate.
That's fine.
No, we can do it.
We'll do it as a block if we could.
Okay, all right. I make a motion, we approve the August 17th and the October 19th, 2021 Board of Adjustment minutes.
Motion's made by Mr. Britt. Is there a second?
Second.
All those in favor say aye.
Aye.
Any opposed? Okay. Next item on the board is a public hearing, determination of conflicts of interest for case number 2022-VAR-01. This is a variance. You've seen the paperwork on this. Jeffrey and Karen Clark Does anyone have a conflict with regard to this case? Okay. This time I would say, I believe staff informed me that,
I was going to say, you may want to appoint one of the alternates.
yeah, I was going to say that staff, Amy informed me that Mr. Edwards was the last alternate who served, so tonight, Francis, you will be the voting member. So Mr. Ward will move up to a voting member with regard to this case. You do not have a conflict, sir? Okay. So this time I would like to read this variance. It is a variance. The applicants are Jeffrey and Karen Clark. They're requesting a variance to table 5.2, district lot and building regulations conventional development. The applicant is seeking relief of a 40-foot from the required 40-foot front setback to allow newly constructed garage to remain 0 foot off the property line. The property is located at 8810 Wingard Road, identified on parcel number 0806-18-0011. Mr. King, where did he go? Is the petition complete?
Yes, sir, it is.
All right, thank you, sir. Again, we've asked if anyone has a conflict, so I'll ask now for a motion to hear the petition.
I'll make a motion, we hear the petition.
Is there a second?
I'll second.
All those in favor say aye.
Aye.
Any opposed? Also, at this time, before Mr. King presents any evidence, if there's anyone who would like to request a continuance of this variance, please come forward at this time. Hearing none, Mr. King, I will swear you in. Sir, are you prepared to be sworn in?
Yes,
Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay, sir.
All righty. So as stated in your presentation, the property is located 8810 Wingard Road, more specifically identified by parcel number 06-186001L. The applicants are Jeff and Karen Clark, and they are also the owners of the property. They are requesting a variance and seeking relief. Now, when we sent out the staff analysis, we did not have a survey on hand. So we did not know exactly how much of a variance that they needed to request. So therefore, just to be on the safe side, staff analysis said they are requesting 40 foot from the required 40-foot setback. As of today, we have received a survey that shows corner of the building being 19.3 feet off the right-of-way line, or what we would consider the front property line. So what they'll be requesting tonight is relief of 21 foot from that 40-foot setback, and this is only for the structure. This will not be for anything else on the property, just that area of the structure that's encroaching into the setback. Property is zoned R40, and in the R40 zoning district, the setbacks are 40 in the front, 15 on the side, 40 in the rear. There's a section in our ordinance that talks about when you have road frontage, that if the right-of-way can be easily defined, such as by a record plat, by pins in the ground or such, then you measure from that point back for the front setback. It says if they're not readily, easily defined, then you measure 30 foot off the center line. In this case, we have both Ben Saunders from NCDOT, who can talk about the right-of-way, and we also have Mr. Carol Russian, who's here, who's a surveyor, that can speak to the survey, property boundaries, and all that tonight. Just to kind of give you a little history why we're here tonight. About a year and a half, maybe 2 years ago, there was a couple, the Merrills, that live adjacent to the Clarks, and they came in requesting a variance for a garage. And in their application request, they stated that there was other detached structures closer to the front setback or road than what they were proposing. With that being said, staff felt an obligation that we needed to go out and verify that there was a possible violation. If there was, then we would need to be able to address the board should the board have any questions about that, since it was part of the application from a previous applicant who later decided to withdraw their application for the variance. So here's some pictures. One's taken from the north, looking down the roadway, and one's taken from the south, looking up at the roadway. And you can see the proximity it is to the hardtop. The applicant is here to speak tonight, and he can explain, what he thought. He went through the proper process. He obtained a zoning or a building permit. On the building permit, he was showing a setback of 70 foot off the property line. We issued the building permit, and he proceeded with the construction, and I believe he has received a CO at this time on the building. However,
Excuse me, Jim, he has a CO?
I do believe you did. It is. Yeah, last year he did receive a CO. However, the applicant did not understand how to measure his front setback or where the front setback was measured from. So if you were to look at his application and where he pulled his 70 feet from, it was essentially from what he thought was the property line on the other side of the blacktop, which essentially, Mr. Russian's here to talk more about that, but I think it was some markers for the right-of-way. Is that correct? So he's the expert on it. I'll let him do that discussion. So Mr. Russian has provided us with a survey. The area in question is this part of the garage right here. The closest point of the garage to the right-of-way is 19.3 feet, and that's why he's asking for a 21-foot variance. We did verify that the house meets its 40-foot setback, and in talking with Mr. Clark, they do have future plans in the future to remove, I think it's a double-wide or modular home, to a stick-built house there. And he's very aware of where the setbacks are pulled from now, and has, told me that this mistake will not happen again. And again, I'll let Mr. Russian stand up here to speak to this survey, to explain to you, where he found the documentations for the right-of-way, where the right-of-way ended at certain times, how it's expanded to, well, the road, the blacktop carries on, but it's my understanding, and Mr. Saunders is here to speak to that, is that once you pass the Clark's property, just shortly thereafter that, the state maintained right-of-way ends. And so basically it's where the curb and gutter section picks up and goes down to a cul-de-sac. But Mr. Saunders, again, would be the expert testimony on that. Just following our typical slides. As far as the developable area, it shows everything in gray is developed. There's some more rural area out there. Any environmental?
Sorry.
Oh,
Where is this property?
this property is right here where the
Okay,
holler.
I'm sorry, I see it now. Dark outline.
Yep.
Had to look a little hard.
And it's dark here too, so, but there are no environmental features on the property.
Where do you want?
How about going back to them pictures you showed a minute? Now, when was these pictures taken?
Our code enforcement officer took these pictures sometime right before Christmas.
Well, one says 1/5/22, I don't know what that means there. We're taking on 1/5, or?
Oh, okay, I'm sorry, yeah. I guess he did take them on 1.5. When I was developing the slide, I'd asked him to give me some pictures, and so these are the pictures he provided me for the slides.
I assume they probably take it the same day. Other one doesn't have a date, but I assume.
Yeah, I would assume they were taking the same date.
Okay.
All right.
Anything else? Okay, thank you.
Okay,
All right.
no problem. The surrounding zoning is all R40, and there's some of the areas that do fall within town of Weddington and Marvin in the general vicinity out there. As far as transportation, this blue line right here shows the extent of the NCDOT state maintained road. And you can see the latter portion of it to the cul-de-sac is not state maintained. There's, again, I'll let Mr. Rushing and also Mr. Saunders talk about, it's my understanding from Mr. Clark that the maintenance stopped well before the house at one time, and there was some reason why the state picked it up, and I'll let him explain that to you. As far as land use costs for single-family residential out there, and of course with a variance, because you're asking relief of the ordinance, it's not like a special use permit. Staff does not make a recommendation for a variance case. And so at this time, if you have any questions for staff, we are available. And there are a couple of people that signed in to speak tonight.
Yeah, I have a question. In looking at the notice of violation, I see there were two issued. To the Clarks and another to Casper Karen.
So the reason that is when you pull them up on the tax card, it comes up as two separate ownerships. So Mr. and Ms. Clark, and I assume when the property was acquired, it was acquired before they were married, and now that they're married, they just haven't changed it on the deed, and that's why that shows up that way.
A lot of issues. I mean, this detached garage looks, it's bigger than the house. I don't, and also, building permit is for a detached garage and a living space. That's all within the code, Jim?
Yeah, you can have an accessory dwelling unit. The accessory dwelling unit has got to either be beside or behind. Well, we just said it's got to be incidental. In this case, the bottom floor is all garage. There's no living area there. The top floor can be living area as long as it does not exceed 50% of that of the principal dwelling. And it's got to be built to North Carolina Building Code.
Is the ownership now strictly with the Clarks?
Yes, that,
Okay, that's all.
Anything? Okay, so, Mr. Rushing and Mr. Saunders are here to give testimony. Are they, I don't really, do I bring them up now, or are they, I don't know.
I think
Are they
probably the
representing
best
you, or are
thing
they
to-
representing the
I think the
owner?
best thing to do would be let the applicant come up.
Okay,
Once the applicant comes up, then if he needs to reference the surveyor or
okay.
the NCDOT representative, he can do them at that
Sounds good.
time.
all right, just wanted to clarify that.
Okay.
All right, and anybody would like to speak in favor of the variance? If you're supporting the variance, please come forward. That would include you, sir, assuming you're the owner. Please come forward. Anyone who plans on speaking, let's go ahead and get you sworn in now. Matter of fact, Mr. Saunders and Mr. Rushing, if y'all just come up here in case y'all are called upon, let's go ahead and get out. Let's just gather around the Bible, and there's another one on this side.
They can affirm,
Two at a time because of COVID.
they can affirm.
Yeah, swear, affirm, yeah. Okay, so we'll do two at a, well, okay, we'll do three at a time. Is that everybody? Okay. All right. Do you affirm that the evidence you're about to give is the truth and the whole truth in this matter?
Yeah.
All right, thank you. All right, make sure you fill out the green slip if you haven't already. Mr. Clark, if you would like to lead this, I'll allow you to start now. And anybody you want to call up to support you afterwards, you go ahead and get started.
Can Karen stand up here with me?
Absolutely.
Thank
If
you.
you'd like to come up, and y'all go ahead and give your give your testimony, and then anybody else, when you want to call up or whenever.
Wonderful, thank you. First off, my name is Jeff Clark. This is my wife Karen. We did get married during the process. We've been together almost 15 years now. A lot of questions. Pretty much the reason why I asked when we came in, what side does the side that begs for mercy sits on? That's what we're here to do tonight. I made a mistake. I've learned from it. I didn't realize it in the beginning. And thank goodness that on June 12th, 2020, Mr. King, who's been extremely helpful himself, Janet Wolf, and Miss Amy Griffin, sent us a letter stating that we're in possible violation. Our heart sank, our heart dropped. We had no idea. We laid out this home and we started the construction process being our own general contractors. And we're able to make it through. During this process, we've had 2 deaths, we've had 2 weddings, and we've had 2 college graduations, on top of COVID. And I mention all that because there was a lot to think about, and we've learned that these builders, they have a lot to think about when they build a home. So in starting the process, I thought I had all of our ducks in a row. When I called out to the house, Mr. Carroll Rushing, excellent surveyor, came out and did a survey for us. I did understand that in the county, when you're R40, you do have a 40-foot setback, front setback. And I looked at where the rebar was and the white PVC pipes, and I measured back, and I said, wow, we're going to be 65 feet off of that. It turned out the survey that came a little bit after was a little bit closer, but was still past the center of the road, which you'll see on Mr. Rushing's survey. So all I had in my head in the beginning was the 40-foot setback. And I said to myself, we're way beyond that, we're good. We come down to planning, we go through the process, we pay for our permits. While I'm going through this, I wanted to answer Mr. Britt's question. When we pulled the permits, another excellent department we have here in Union County, extremely helpful. Rick Wilkerson and Tommy Helms, I cannot thank them enough for walking us through this process to 2 people that have never built a home before. What they explained to us, Mr. Britt in particular, because you asked the question, is we showed our blueprints and showed what we wanted to do. The problem was there was a viable double-wide modular home sitting on the property, which we were living in. So the person that drew the plans for us said, here's an option. Why don't you build the first half, the garage with the upstairs, build that portion up to the mudroom and stop. I was like, okay, then what do I do? Well, we have some buyers that are buying the modular and moving it off of the property, and then we would do an addition off the side. Well, I didn't know how to go through the paperwork, but Mr. Wilkerson and Mr. Helms, they said, we can do this. You got a minute. So we ended up taking our blueprints and all of our drawings, and we went back in the office, we laid it out, and we laid out a plan. The plan was for Karen and I to pull, and at the time she was Karen Clasper. At the time, they had us pull 2 permits. And I won't get the wording correct, but the best I can remember the wording is you cannot build an accessory structure that is bigger than your primary structure in Union County. Unless, is what they told us, unless you go ahead and pull the permit for the final structure as well, because they are going to be attached. So hopefully in the next year or 2, you're going to see final project, it looks like one house. Right now, in the pictures you saw, you see the new construction, log home, stone bottom, and you see a modular home sitting next to it in a space of about 18.5 feet. That space will be gone because that's the width of our mudroom. So in doing that, we were allowed to pull both permits at the same time. I think it was 699 and 700 were the last 3 digits of our 2 permits, which would allow us to build the garage structure and then come back and finish. Getting back to the setback, the other thing we found during the process that we had been under the understanding, is that the best way to explain it, is the state right-of-way setback. So the way it was explained to us in 14, and even before 14, because I knew Mr. Wingard and his brother a few years before we bought, The way it was explained to us is that this right-of-way was put in for the school buses. The school buses were getting stuck in the mud. They were going in the dirt and gravel of Wingard Road, coming out of the neighborhood of Walden Pond, turning around in Earl's driveway and getting stuck. It was presented that, hey, if you guys allow us to put in a right-of-way, we can get that paid for you, which is what the Wingards did. It was shortly after that, the very first school season, school year, after the road was paved, Union County Busing stopped all busing transportation on that section of Wingard Road. Mandy Benton is the supervisor of Union County Busing Transportation, and I've been in constant contact with her the past few years because that information was vital because of the fact that Union County does not allow school buses to travel onto private land. And I think Mr. Saunders will explain, it's private land, but the state does have this right-of-way that's on top of it. So the very first school year after this right-of-way was put in, the buses stopped traveling on that right-of-way because of it being the land that it was. So at the time, we were being told that school bus right-of-way is not even in effect anymore. It was taken out of effect or abandoned back in 1995. So
Earl and Ralph were telling us.
that's what Earl and Ralph, our neighbors, were telling us.
They were
Come over
grew
here,
up on the property.
stand in front of me.
It was their father's land, and they grew up, so we
Yes.
heard all these stories from Earl and Ralph about the school buses don't come back here anymore because of the situation, and Earl kept saying, oh, that school bus, that right-of-way is gone, so our bad, we should have obviously looked into it a little bit more, but
That's where our biggest mistake is. Our biggest mistake is that we didn't do the research to find out that there actually still is a state right-of-way. And, what's the difference? Well, the difference is the state has the first 25 feet of this right-of-way. It's a 50-foot right-of-way, 25 foot off either side of center. So when we found this out, we were 3/4 of the way. Well, we found this out,
when we got the...
honestly, when we got the letter from Jim on June 12th, 2020.
Yeah, we had no...
We said, oh my God, we have a state setback now of 25 feet. I said, well, we're 45 feet off the center of the road, so we got to be good for that. And then I said, well, even with Mr. Rushing's survey not being all the way to the rebar that was marked, but still going past center of the road, we're still 47, 48 feet from where the property line is to the corner of the structure. So I still thought, heck, we got to be good. So we got Mr. King's letter, we contacted him, we talked. That is where we learned our biggest mistake. You have to take the state setback and the county setback, add them together, and measure that off the center of the road, which we had no idea. The past year since that letter, it has been us working diligently daily.
It's been very stressful.
Stressful.
Needless to say, I just...
We've been following everybody from planning, everybody from permitting, anybody that was willing to offer some assistance and guidance. We followed every option that they gave to us. One was do the abandonment. Said, you guys can abandon this right-of-way, the state right-of-way. So that's how we got to meet Mr. Saunders. We went through that process, and we thought it was going pretty good. As Mr. Saunders said, this one is one of his easier ones because of the fact that there was only 4 houses that were adjoining and abutting. So
But
we
that
went,
turned out to- we
yeah.
needed more signatures than originally he had thought, so we weren't gonna get some of the other signatures, and we didn't wanna like push the envelope with any of the neighbors, because we didn't wanna start any kind of problems.
Any
So we
issues,
just-
yeah.
We did try to get another signature that, first it was,
Come this way, honey. So-
initially he thought it was 4, then his bosses added 2 more on, and we got 1 more. They were in the process of selling the land, and then we went to the new homeowner, and she was willing, but then we still needed another, then they weren't willing, and like we said, we didn't want to, cause any trouble, so at that point, we thought about some other things that we could possibly do, maybe reduce the right-of-way, but the state said they couldn't do that because it
It's
was
already
already
at
at
50.
50, and then we thought, well, what about shifting it, and that wasn't an option either, and then we talked about possibly putting another private road so that the front of our house would be
So the front of our house would be the side of our house, and then we'd have
And then maybe
a
that
new
would be a
entranceway.
little bit
That
less.
would be the front, which
But
would
we
make our
needed-
sideline 15 feet
But I think we
setback rather
needed-
than 40, but.
We needed more than 3 addresses, I think,
Yeah.
to do that, so we really ran out of options, and so here we are.
So to summarize, I'm sorry we're throwing all this at you.
I understand, sounds like you guys have had a rough couple years here.
And
I can't
I
even
just want you to be
explain.
rest assured that
Yeah.
this was a mistake, and we did not
Right.
do this intentionally.
This
and
was us.
It's
It's on us.
It's,
It's on me.
we've been building this house for, I think we started framing in 2 days before Thanksgiving in 2016. And we're finally at the point where we can actually.
Well, we've done it. We've done it. We got our
And-
CO last year, and we love
it's-
it.
That's
it's
another
been-
thing, you got your CO.
Yes,
You want to build houses for a living?
I'll tell you, the most rewarding part about it, I think you would all attest to this, is you get things the way you want them, and if you're a very particular person, you get them particular.
I hear
You
you.
don't have to settle.
I understand. Anyone else who you would like to give evidence at this time?
Any questions? Can we answer
Yeah,
any
anyone
questions?
else would like to ask any questions of these folks at this time? Yeah, if you want to bring Mr.
Thank you.
Saunders.
Thank you very
or-
much for listening to us.
Mr.
We
Saunders,
didn't know
or,
what to bring, so we brought everything. If you have a question, we should have it.
Mr. Saunders or Mr. Russian or whoever else you wanted to speak. I don't care what order. Mr. Saunders, I guess. You're up first.
Mr. Chair, there's a few people that have filled out the paperwork to speak. You
Yeah, if
want
they'd
them
like to
follow
speak.
Mr. Saunders?
Sure, let's hear from him and Mr. Russian.
So, as he alluded to,
And you are Mr. Saunders, I'm
yes, I'm Ben Saunders. I work for NCDOT for Travis Pressler, who is the District 3 engineer.
Okay.
He wanted to be here, but he had to go to Raleigh for a conference, so I'm here on his behalf. And I dealt with them on the abandonment. They've also dealt with our office and some of my colleagues in Albemarle on several other things that they mentioned. I can only personally speak to the abandonment, but I have notes from everybody else, so hopefully I can answer your questions. Technically, the abandonment is still active. I don't close anything. I would ask them to close it if they felt they need to close it. And we'll keep it active for 3 years, I think Travis has decided, if we need to. We just don't close them unless somebody requests them. They did get the signatures they could. There was signatures added later by me after I found some driveways didn't connect to what I thought. And then Mr. Pressler added even more signatures after reading our manual. So he now would like everyone on the private section to sign because technically they're accessing a state road. Also, someone that did sign it, family member called and said they had a power of attorney and they wanted to hold up a signature. So they've had to deal with all kinds of problems, but they've done their due diligence on the abandonment, and it's just kind of in a holding pattern. People don't want to sign, I think, and that's not on them. The right-of-way is 50 feet. I confirmed that with our right-of-way person the other day. I was hoping they were going to send me some records, but they didn't get them to me in time. And from talking to several of my other colleagues in the office, and some email stuff I have here, they have tried to shift the right-of-way, and Mr. Pressler denied it. They tried to reduce the right-of-way. Mr. Pressler denied it, and they did try and abandon the right-of-way in front of their house, and that as well was denied. So they have jumped through all the hoops the state could ask them to at our level, and we just weren't able to help them. I mean, of course, if they can get the rest of the signatures, then we can proceed with the abandonment. But at this time, that doesn't look likely.
All right, Jim, could you come up here and bring up the picture again of the, where the road is?
I have one question. When did the 3-year period start?
Last summer.
Last summer?
Yeah, so it'll be 2024.
So the right-of-way goes just past their house. I guess there's one lot, looks like, but
Yeah.
all those people, obviously, like you said, they access it, so
Yes.
they have, but, so we're talking about how much distance past their property line roughly you think that is till it ends? Do you know that answer, or is it
I
just?
don't have that answer
Okay.
written down, but that map looks accurate based on
So
going
it's just
out there.
basically one more lot on one side of the road and one lot on the other side of the road past there,
Yes.
it looks like to me. Okay.
Yeah, and one of those lots, actually, I think, right in there, might be, there's a lot that's half on our right-of-way and half on the private.
Right. And I'm sure, given North Carolina DOT standards, that's a really nice paved road that y'all take care of every time it snows, and I'm just
You know how
kidding.
that goes.
I'm just kidding. All right. Any questions for Mr. Saunders?
Yes, sir.
Yes.
Is there any mention of what any other requests would be regarding the right of way?
You mean the ones I was speaking about for other people? They just don't like to alter the right-of-way, usually. We don't mind abandoning roads, and if someone wants to do something with the right-of-way after we abandon it, we usually don't abandon right-of-way if we're going to keep the road, is my understanding.
But from that point forward, it's a private road.
Yes, and then they would do whatever they wanted to with
Right.
it.
Okay.
And I also should mention, I recently took a phone call from someone who wants to add the rest of it.
To the state.
But I told them we have an outstanding abandonment and we cannot take any more road if we're potentially going to abandon a piece in the middle, because that's not something I don't think my bosses would like.
Sure.
So I kind of postponed that.
All right. Anything else? Okay. Thank you, sir.
Yes, sir.
Mr. Rushing, if you'd like to come forward at this time. State your name for the record.
Yes, sir. My name is Carol Rushing. I'm a professional surveyor in North Carolina. And we went out last week. I had surveyed this property before. Okay. And we went out last week to check the new addition to the property. And we based our survey originally on a survey done in 1975, and it was a division of the J.R. Wingard property. And the Wingard Road stopped right in front of Mr. Clark's house at that time. And basically this Wingard Road has changed a little bit. When you first approach their property line crosses the road to the southern part of the pavement. And that iron pin, well, there's an iron pin in there, and it's got a distance from an old stone back up the property line to verify that, and it's just to the nitty-gritty, it's good. And we reestablished the old property line in front of their house on down. But when we went last week to do the survey, Mr. Clark come out, and he was telling us his property line was across the road on the south side, and I said, no. I said, that's not where it goes. And he proceeded to show us an iron pin, and the iron I was just telling you about, that when you approach the property is on the south part of the pavement. It looks like it kind of matches everything on the south side of the road. But the iron pin he showed us is a property owner coming to the road on the opposite side. And surveyors usually put a property corner on the right of way of the road as you approach the center line of the road. Most properties go to the center line of the road in the county. And so I told him, I said, that's the first time I'd seen that iron pin, and I've kind of established that's what it's for. It was a point on line is what it was. And so he had been told wrong, informed wrong about where his property line was. And so we got a good survey going back to when it was established. So and that's about all I can tell you. It just that there is a DOT right-of-way, I think it was done in 1994, establishing that 50-foot right-of-way that they were just talking about. So that's about all I can tell you.
So
I think Mr. Clark was misinformed the whole time.
But this is your professional testimony. This current one is this is the right one. The one you
Yes,
said.
sir, I go
It
to
is.
court with it.
It's good.
It's good.
I hear you.
That's my job.
You've been around a while.
Yeah, I am.
I trust your judgment, sir. Thank you. Any
Okay.
questions for Mr. Rush?
Yes, I have a question. So the iron pin, the new iron pin that you found, is this the found rebar on edge of asphalt? Is that what we're talking about?
It's on the edge of asphalt, and if you go up that line, you'll see, found tack in old stone, about, I think it says 280 feet up that line. And we've got a copy of the 1975 survey, and it's that same distance to the iron, so, that iron pin's right. That iron pin can't be the original iron because the road's been put in there, and, somebody had put it back, but they put it back right.
Any other questions? All right, thank you, sir.
All right, thank you.
Okay, anyone else at this time who would like to speak in favor of this petition? Please come forward.
Well, I'm sorry, can I
Oh,
ask
I'm sorry.
Mr. Rushing one more
Okay,
question?
Mr. Rushing?
I'm sorry. You said that the clerks have been misinformed about the extent of their property line. I'm not sure I understand.
Well, he was told that it went across the road from his house, and there was, he showed us an iron pin.
Okay,
There's a property that comes in from across the road to the road, and like I say, surveyors usually put an iron pin on line before you get to the center of the road or in the road, because a lot of times they get paved over and you need a reference point on line so you can keep up with your property line.
so was that an old survey that showed the iron pin across the road?
It goes back to the 1975 survey, yes, sir.
Okay, so your current survey, where we see in the top left corner here on the screen, found rebar on edge of asphalt, that's on the far side of the road. But then
That's
as you
on the
get to
far-
their house, where it just says Point in Road, there was an old survey that showed that across the street? Or roughly there? You say across from their house.
No, there is a property that comes in perpendicular to the road from the property across the street.
Okay.
Carol,
Yeah.
you use the mouse to put your cursor on there, and they can see the cursor of what you're talking about.
Oh, I see what you're talking about. All right, let's see. Somewhere right in there, there's a property line that comes in, and that iron pin was right in there across the road, on the south side of the road.
Okay.
I didn't locate it because it was kind of immaterial at the time.
Sure, okay. I'm just trying to picture where this was. Thank you.
Yeah.
Okay, thank you. If you could please state your name,
Melanie Cardassi,
your address,
8819 Wingard Road.
okay?
We are the neighbors that live north of Jeff and Karen, and we're probably the stake that Mr. Rushing is speaking of, because we're at an angle, so we're in front of Jeff and Karen, and we're also adjacent to them. And we have no objection to it. We find the structure to be an asset. It's extremely solid construction. We are the part of the road that Mr. Sanders refers to, where the right-of-way that the state asserts, and then the private portion is on my lot. So that takes place, I'm the transition point. And we've been maintaining it. We've owned it since 2013. Jeff has been maintaining it. We've been maintaining it. We just have no aversion to anything that he's doing. It's a very appealing structure. It's very aesthetically appealing and suits the area, and we believe it will be favorable for the comps, and can't say anything opposed to it at all.
All right.
And if there's any question that I can help you with,
Questions? All right, thank you.
thank you.
Please state your name and your address.
My name is Mahmoud Kardasi. I'm at 8819 Wingard. That was my wife. I
Okay.
just want to add on what she said. Everything about the house she said is correct, but I want to speak to the character of our neighbors. Karen, Jeff and Karen, you know, they're the best people you can ever have as a neighbor. Jeff, for being a public servant, you know, he's a firefighter. If you guys vote for him in his favor, that will ease his mind and he can do his job a lot better. And if you have any question, I'm willing to answer.
Questions?
Thank you.
Thank you, sir. Anyone else who would like to speak in favor of this variance at this time? Okay. Seeing none, is there anyone here who would like to speak in opposition to the variance? If you would, please come forward and be sworn. Not all at once. Okay. Seeing none, Board, do you have any other questions that you would like to ask before I close the public hearing? Once I close the hearing, we do not take any more testimony. It's done, okay? So if anyone else has anything they want to say, now it's time to say it, because I will close it and we will begin deliberating. Seeing none, at this time, I will close the public hearing. And Board, we will begin deliberations. There are some findings of fact that we need to look at. There's 5 items. The clerks have presented their answers to these 5 items. If you would like to look at those, they are in the agenda. They are number 1, and I will ask that we vote on each one of these, and then I will ask for a motion. Item number 1, the strict application of the ordinance will result in an unnecessary hardship, but it is not necessary to conclude that the strict application will prevent any reasonable use of the property. You see what the applicant wrote there?
I'm good with what he wrote.
Well, it definitely would be a hardship upon them. And necessary, unnecessary, it's always a thing to wrestle with, especially when you get down to 5, or rather 4. You know, the self-created situation. But it seems to me that, you know, there's a lot of players in this, including the county, you know, and so on and so forth. Now that I know the full plan to add on and then remove the other structure, it makes me feel a lot better about this whole variance request. So, anyway.
Okay, I would tend to agree with both of what you said, and at the same, and I would further say that it didn't seem like anybody anywhere along the path said, "Stop! You can't do this." County went out and approved everything, and building gave them a certificate of occupancy. It wasn't like they thought they were. I don't think there was any intent to do anything wrong here. So all in favor that they meet this number 1, say aye. Aye.
Aye.
Any opposed? Number 2, the hardship is unique, of this unique, the hardship is unique to the subject property rather than common to the neighboring properties or the general public. I believe that the discussion was that, as Mr. Russian pointed out, there were some issues with regard to where is the property line, and also the right-of-way ends right past this property, the state right-of-way. So in addition to the things that they've pointed here, I think it is somewhat unique that they're right there at that point where things end and begin. Anybody, anything to add to that?
No.
I think it's also that these are larger tracts, so if the correct information, if you had been informed along the way, this wouldn't have happened, because there's room in the tract to move this, it's just,
Yeah.
just that the information wasn't accurate.
Yeah, Yeah, it seemed that he was looking for the right, he actually measured and looked, and thought he was right, and he would, and if he'd have known this, I'm confident he would have put it right. Okay, all those in favor that this, number 2 is met, say aye. Aye, any opposed? Number 3, the hardship relates to conditions peculiar to the property, location, size, shape, topography, rather than personal circumstances of the applicant or owner. From obviously from what I was looking at from the pictures, where the modular home is, in order to build this, they would have, if they there wasn't a lot of options there. I mean, he could have set it back a little bit, but again, we go back to that whole thing where he thought he was measuring right. It does come into a triangle there. And the whole school bus issue, as he stated in his notice. Anything?
I don't have a problem with the,
Anything? Sir? Anyone? Okay, all those in favor that this item is met, say aye. Aye. Opposed?
No.
You said yes, sir?
I said no.
You said it wasn't met.
Right.
Okay, so note that is, that was a 4-1. Okay. Number 4, the hardship is not the result of actions taken by the applicant or subject property owner, although the act of purchasing the property knowing that a variance may be needed or required does not constitute self-created hardship.
Larry started to ask about this, and I looked at some case law today just to give you all an idea, and there is some inference of fault built into this. So to the extent, I mean, obviously, if this were intentionally done, you'd have a problem, or if this were, negligently done, you'd have a problem. But to the extent there may have been some to the extent you believe that they were, misled, or there was misunderstandings, or there's confusion in the records, or whatever that may be, you can take that into account. The way it's phrased here, it sounds like, well, anything the homeowner did, they must, if they had anything to do with it, you can't grant a variance. Well, then you'd almost never be granting variances, for one thing. But again, looking at the cases before the North Carolina Supreme Court, there is some feeling of fault built into that. I just want to, so you got to kind of think about what was in their minds when they were doing this.
thanks very much. It's difficult to grasp sometimes a hardship, self-created hardship. But I also, when I read through this, I thought that they didn't even have a survey when they started, but they did. So, if you would have started the project without a survey, not a good thing, but they did, so, anyway. And they did try to meet all the requirements, so.
I have a question, maybe for you, who in the normal course of this would have caught this?
The inspector.
Yeah, surveyor. I mean, here it just looks like it didn't. Admit maybe there's some steps in it. I don't know. I'm not finding facts for you guys. So it's possible from the record you've heard that you just found some facts. So I don't really know the answer to that. That would be more a question for Jim, which you can't ask him right now. But if you're
Yeah, we can't ask
afterwards.
Jim because he's not allowed to. I would say this, in my opinion, this is not the first time this has happened. And it's, every time I've seen it, it's been an accident. It's never been, in my opinion, in my time on this board, it's been a while. No one's ever went out and built something and said, oh, I built it because I knew. I mean, well, maybe they did or didn't, but I don't think, based on the evidence, and we have to listen to that. We have to hear the people speak to us. Do we think they intentionally did this? They went out and said, well, I'm buying this land, and I know I ain't got the room to build it, but I'm going to build it. I haven't seen that, and I don't think that's the case here. I think personally, and this might be something we need to send to county management, that inspectors who go out and, as Mr. Smart, brilliant attorney we have on our board here said, I think our inspectors need to be looking for stuff like this, and I don't think they do.
Well, I got a problem with the whole process.
I don't think they look at it.
The people down in inspection should not have been helping him get this project going. They shouldn't have said, well, we can do this. They should have said, you need to go. to
Here's the rules.
or something.
Well, here's the book, here's the rules. But the bottom line is, when you go out and inspect a piece of property, I think the building inspectors go out and look, well, is it structurally sound? Is it safe? Is it pretty? Does it meet all the requirements? They don't look at the setbacks. And Mr. King had no idea, probably, that there was a building permit, because it's not his job. His job is zoning. And so, anyway, a lot gets missed there, and I suppose,
They really should be looking at setbacks.
yeah, they should look at stuff like that. Before the permit's ever even issued, that should be looked at, but that's another question for another day, and that's not,
This building shouldn't even have been allowed to be built because it doesn't comply
right.
with the size of the existing house on the property. So
There's a lot of issues
a
there,
lot of issues I have with the county that somebody needs. to-
but it's not in my opinion, based on the evidence I've just heard,
Wasn't there?
it's not the the owner's mistake, it's the county's mistake, and that's why we're here. So, number 4. Any other questions about number 4? Okay, all those that believe that number 4 has been met by the petitioner, say aye. Aye. Any opposed? Got one no here, so it's 4 and 1. And number 5. By granting the variance, the spirit of this ordinance will be observed, public safety and welfare will be secured, and the substantial justice will be done.
I think the fact that, no one came to speak against it says a lot as far as, the neighborhood and the safety and welfare of the neighborhood.
So we're short by 21 feet. That's it.
21 feet, yes.
So it's in compliance.
Yeah, 21 feet. So it's roughly half of what it should be. Should be 40, it's 21. That's 19, I believe 19 and a half or something like that. Again, I go back to my position on this is that this is a piece of property. If this was on a main highway, then there would be a question about traffic, and I'm sure we've seen the map. This goes into a cul-de-sac. I can't imagine there's a ton of traffic that goes through here. I believe setbacks are established to protect safety from people being close to main roads primarily and to protect other property owners. Again, as you stated, Mr. Britt, we have not had anyone come forward that's been opposed to this. I don't believe the one neighbor did come and spoke in favor of it. So we have
something somewhere about it being on a straightaway too.
right.
So you don't have a blind curve or anything. I don't remember.
Not a
I
blind
saw
curve. As we've noted, school buses don't go down here. The reason we have variances is we wouldn't have to have a variance if we didn't have to have a variance. Variances exist because of situations, where things don't fit and things went wrong somewhere in the process. And so, like I believe Mr. Thurman said, if we took some of these things strictly by law, it'd be kind of hard to ever grant one. Is that what you said, basically?
Well,
Well, I mean,
in this circumstance,
and then, yeah,
obviously, we've had situations
Well, yeah.
where the
It's-
property's just unusable with the.
Oh, yeah, we've had
There are
those.
other situations, but
I don't see anything hurting the public welfare and safety by supporting this. So
I agree.
at this time, I would call for a vote on item number 5. All that believe that this item has been met, please say aye. Aye. Any opposed? That was 5-0. Okay, those are the 5 items. Do I have a motion?
Make a motion that we approve the application for variance of 19 feet, or 21 feet, I'm sorry.
Was it 21? Are we sure it's exactly 21? I don't want to.
Can you add to the affected area only?
Yes.
In other words, it would only be granted for that little part right there, not no other part of the property.
Right.
For the footprint of the existing garage structure,
Yeah.
something along those
Okay.
lines.
Would you agree with that?
Yes. For the
Is
existing
that
garage
acceptable,
structure.
Mr. King? I'm making sure that, I don't want to put something in the motion and then we come back and we should have added a half a foot or something.
In reference to the survey, the survey will become an exhibit.
Okay, in reference to the survey. Is everybody okay with that motion? Do I need to repeat that motion? Because if I do, I'm in trouble. Well, I can state it, I'll try, but the motion was to approve the variance for 21
Feet.
feet to keep the current, only for the current footprint of the building,
Garage
the
structure.
garage structure that is outside of the right-of-way as per the current survey dated January 22nd,
January 18th.
January 18th, 2022. Okay? That's the motion. Is there a second? Second, Mr. Tilley?
Yep.
Mr. Britt made the motion, Mr. Tilley seconded it. Any further discussion? Hearing none, all in favor say aye. Aye. Any opposed? Congratulations.
Thank you.
Sleep
Thank
well
you.
tonight.
Go fight some fires. All right, item C is determinations of conflicts of interest for case number 2022 appeal-01. Do we have any conflicts with regarding this appeal, which is item number D?
No.
You need a break?
Yeah, just quick.
Okay, we'll take just a minute break, let everybody, Mr. Britt's gonna use the restroom. I don't know. There is a rumor that's gonna ask for, they're gonna ask for a continuance. So that's probably the case, given the fact someone's here. Whew. Yes.
We can do it in ordinary, we've done it. So basically, as long as it's just paid for the way it's taxed, yeah, those are the things.
Yeah.
And then he hasn't abused the bill, he hasn't done it.
Right.
See y'all later.
And he's,
Board, thank you very much for the compassion, allowing us the time to present. We can't thank you enough, and we apologize.
thanks, sir.
Thank you.
I don't know. That's a county issue that somebody down there needs to fix.
But I mean, when you ask for a survey, you ask for a survey, but.
Well, that's true, too.
So,
True,
there
too.
may be, I can't see Carol.
Carol's been around forever, 100 years.
I've always used Carol.
Yep.
He's always such a good worker.
My dad always used Carol. All right, we got,
The line fence came out of my house and made sure my porch was in the right place.
that makes, I don't understand.
Before we even start, we had to have it staked out.
I don't understand.
But you can't tell me the space of this building on the house there.
That's true. Okay. Okay, item D is an appeal. 317 Properties LLC submitted an appeal to the notice of violation CZ 20210051 that cited the change of use without obtaining a zoning permit. 317 Properties LLC was cited in violation of Union County Development Ordinance for a change of use that was inconsistent with the approved site plan. The approved site plan was for an unmanned warehouse, and the new use of the property consisted of outdoor storage of vehicles, both operable and inoperable for repossession business. The property is located at 4521 Helms Road, identified by parcel number 05-141-007D. At this time, I believe that is the petitioner here, or their representative. So if you come up, I believe you're going to ask, I understand you might be asking for a continuance, so if you just come forward.
Yes, sir, I've been working with,
Just come forward to the, please come to the,
My name is Robert Batchelor, and I have been working with Mr. King to come into compliance.
Yes, sir.
The zoning use for that, based on the county code, is a right of use zoning, and it doesn't require any kind of special approval or anything. And so I was unaware of the fact that you had to have a zoning letter for, for that. I just thought that it fell up under that use. But I have been working with Mr. King to come in compliance with everything in order to accommodate that zoning.
so you're asking for additional time to get.
I'm asking for a 60-day continuance in order to get all of that in place, because I'm waiting on my engineer to actually give me the site plan with the requirements that Mr. King has outlined for that.
Okay, did I make that, do we have to vote on that, or?
Yeah, you don't vote.
Okay, so,
The rules for continuances are in the,
Yeah.
what is the document called, your bylaws, I think. But basically, is it in good faith? Have there been prior continuances? Does anybody object? Is it a legitimate request? Those are kinds of things you should be thinking about when y'all vote.
is there anyone here would object to the, anyone who would like to speak in opposition of us continuing this?
Well, I would if I can, so.
So I have to swear him in, or he just can speak, or how do I do this?
Yeah.
It's fine.
Just swear, man. Just-
Okay. You swear that the evidence or you swear or affirm the evidence you're giving is the truth in this matter?
I do.
Okay, please state your name.
My name's James Edmondson.
James Emerson?
James Edmondson.
Edmondson, okay.
Yeah. I'm at 5003 Catherine Antoon Circle.
Is that close to this property, or?
It is adjacent to it. I was
Adjacent.
notified
Okay.
of the hearing. I mean, I did a little bit of looking at it myself. I have the parcel report here with it zone light industrial. So from my observation of the property and what's going on over there now, light industrial, there's a difference between light industrial and heavy industrial. You guys probably know all this, but let me get my glasses on. So the reason for the two designations is one could have a significant impact or adverse impacts on surrounding properties.
Well,
Mine being-
I guess my question would be, your reason for opposing us continuing it till,
Well, it's being used as a junk or salvage yard, which is not allowable under light industrial zoning, in my
Okay.
research.
so you're opposed to us continuing it and allow the owner to have extra time to bring his case?
Is it
Because
trying to
it's-
rezone the property, I guess, is my question? Or is the zoning staying the same? If it is, then it seems to me that it's being
I think that the
misused.
thing is, he's asking for additional time to get that figured out, so.
Well, that's fine. I just wanted to go
I
ahead
understand.
and speak
Well,
since
I-
I'm here, but.
I guess I appreciate you coming, and the thing is, he's asked for, and normally we grant continuances unless it gets to where they come, if he comes back next time and says, I want another one, then probably not gonna happen. But yeah, I never asked for one, so it's like, is there a blaring issue that he shouldn't be given an extra 60 days to?
No, not at all. I just
Okay.
wanted to, make this, aware of this, and I came, and,
Well, I
I'd
appreciate
rather
you
not
coming.
come back, but. I
And
will
if we
back.
grant this, you come back in 60 days, you can come back, if we grant it. We may not, and you can come back up and give us more evidence in a minute.
Understood. Thank you.
All right, thank you, sir. Thank you for your time.
You should get notice of the next one.
You will absolutely, if we continue it, I believe they will send out another notice. Is that correct, Mr. King?
Since it's already been advertised by law, we don't need to send out another notice.
Unless we tell you to?
Yeah, if you request it, we'll definitely be happy to do it.
All right.
Yeah, I would request it, definitely.
Okay, well, I need a motion to,
Okay.
I need a motion one way or the other. We continuing it or not?
I make a motion to let them have their continuance.
For
but
60 days?
For everybody to be notified before the next meeting for this comes up, like they were the first time.
I'll second.
Motion is to continue it for 60 days and require notification be mailed to all previous persons notified. Motion is second. Motion by Mr. Tilly, seconded by Mr. Britt. All in favor, say aye. All right, well, did you second? I don't know who seconded it. You know who seconded it. That's what my, all in favor, aye. Any opposed? All right, we'll see you back in 60 days or whatever that date is in, I guess, March. Is that correct? Mr. King?
Yes, that's correct.
Okay. Any other business to come before the board at this
I
time?
have a quick question for Jim. Jim King? Jim, on light industrial, maybe you could send out an email tomorrow, what section of the code to look that up?
Yeah.
Okay.
What staff looked at, we initially,
Jim, could you come up so we can hear you? And I don't know if we should, yeah.
when we initially sent the notice of violation, we did not know what was going on. All we knew is there's a bunch of cars there.
Okay.
And so we
I don't want to
cited,
get in evidence being presented right now, so if that's what you're about to do, let's don't do it.
okay,
Okay.
Yeah, just, if you
Yeah,
just.
because this is,
send me the
this is
code
for the
reference
board,
and I'll-
for the board's reference, this is a matter where staff is actually involved in the case, so we really don't communicate with staff on this issue, because they're on one side and it's different with this, with appeals. The staff makes a determination, and it's kind of a fuzzy area, so we stay away from staff. Don't ask them no questions.
Okay.
If you have any questions, ask Amy, because she's not making decisions over there. They just make copies and do all the work while they go out to lunch. Apparently. Anything else to come before the board? If I could, I would just like to, tonight, to state that for the county's reference, the county lost one of our mayors today, Michael Alvarez, the mayor of Indian Trail, passed away this morning.
Yeah.
Please keep his family in your prayers. At that time, we have a motion to adjourn.
So moved.
All in favor, say aye. Aye, any opposed? Thank you all.
Good job as always. Thank you, guys. Do we have February meeting?